A probate asset is something that passes through probate, meaning when your will is probated with the surrogate's court, and that process has authority over how those assets get administrated, whether it be to pay debts or to be distributed to the heirs that are named in your will. A non-probate asset is something that passes what's called by operation of law, so outside of probate. And the best illustration of that is your 401k, life insurance policies, an IRA or an individual retirement account where you've designated a beneficiary with the banking institution, and the banking institution is going to honor that designated beneficiary and pass the assets directly to that person or charity. The importance of understanding a probate and non-probate asset is that a lot of people assume that their will dictate what happens to all of their assets. And it's an important distinction because your plan can be disrupted if you don't understand that. And so there's a lot of intricate rules that are involved in it, and a lot of people think, well, it's just a document, it's just a form. But beyond the document that you're executing is where will each of these assets go when you pass away, and is that exactly how you want it to pass? The other thing that I would say about that is sometimes people name their minor children in the non-probate assets, and that's really not what you want to do because minors are not competent to own property under the law, and so you don't want $1 million IRA going to a minor child, which is going to necessitate another layer of process with the court, which would be a guardianship. I find that a lot of people go into the process saying, this is, again, just a form, and I can fill out the petition myself. In some cases, that is the case. If I have somebody who has a simple administration, the person dies without a will, but there's under $30,000, they can likely navigate that on their own with the court. For a lot of other people, particularly if they're busy professionals or they have a family of their own and they have matters to attend to, it can be a frustrating process because, like with anything else, people who do this a lot know the ins and the outs and what has to be done rather than having to go to the court multiple times. So more often than not, we find that people come back to us and have us facilitate the submission of the petition, making sure that we're following up with the departments in the surrogate's court and getting them what's called their letters, whether it's letters of administration or letters testamentary, which is effectively their authorization to act, kind of like being deputized as a sheriff.